Cool. So it's a great pleasure to welcome you all for this new webinar. We are delighted to hold this webinar in collaboration with the European Commission to present you the Data Act and the different ways to ensure compliance with this new regulation. I will then start by introducing our webinar agenda, first of all. So we'll start today by a brief introduction, then an introduction to the Data Act. What are these new obligations contained in this regulation, which is impacting many entities across Europe? The description of the Data Act obligations for SMEs in particular, Data Act criteria for self-assessment and certification, where we will be presenting the result of research activities at the European level through the European Research Program to support the assessment of compliance with the Data Act. So to enable companies, public administration to easily assess if they are complying with regulation and potentially to even certify. And then we will have some Q&A according to the time available and the conclusion. So it will be a quite dense webinar. We decided to have a deep dive into the Data Act. So you can expect that the whole webinar will be about 2 hours altogether. We will record it so that for those who would like to review it and at a later stage, they will find it available online. So it's my great pleasure to welcome Dr. Malte Beyer-Katzenberger, who is the team leader of data policies at DG Connect of the European Commission. As you know, DG Connect is in charge of the Data Act. So it's a great pleasure to welcome you, Malte. Would you like to say a few words of introduction, Malte, before I give the floor to?
With pleasure. Thank you, Sébastien. Happy to be here. I understand I can't really show my face because the videos are disabled, but that's fine. You see me, how I look like on this more recent picture. I think it's a bit of a discovery for me as well to understand the method that you apply to certify. We have been exchanging before, obviously. I have a certain idea how the certification frameworks that you work on function. And I'll try to respond as best in my presentation to this, and then we can maybe also look what it means actually to be compliant with data. It just triggered a bit of a thought because it's competition law, and competition law compliance is tested ultimately in courts, but whatever we can do to show compliance upstream, very good. Happy to be here.
Yeah, thank you very much, Malte. I have the pleasure to have also with us Vasiliki Tsampanidou, who has been working from the research side on the development of the criteria for the Data Act. Vasiliki, would you like to say a few words? Introduction?
Yes, with great pleasure. First of all, thank you for having me, and thank you everyone for joining this webinar. Throughout this webinar, you will learn a lot more about compliance with the Data Act, and we really hope that you will find it useful. So we are looking forward to having you actively participate as well.
And then I have the pleasure to chair this webinar, and I will share also some perspectives. But my name is Sebastian Ziegler, and I have the great honor to serve as president and chair of the Europrivacy International Board of Experts, which is in charge of maintaining and updating the European seal, Europrivacy, but as well as to support the research development of the European Centre for Certification and Privacy. Let me just say a few words about the European Centre. The European Centre for Certification and Privacy was established in the context of the European Research Program for the result of one of the European Research Project to support research or to bring research and innovation to support regulatory compliance and certification. The European Centre is based in Luxembourg and is acting fundamentally as scheme owner, as if you want, standard development organizations that support the transfer of research results to the market. ECCP is not delivering certification, is not delivering consulting services, but it's working with an ecosystem of qualified partners who apply to be recognized by the European Center and then can receive free licenses to use the different schemes and resources that are made available by the center. Without further ado, let's dive in the webinar itself. A few general information. The webinar will be recorded and shared online. You can ask questions through the Q&A feature. If you have any question, we'll try, if time allows, to answer them at the end of the webinar. When you are not speaking, we invite you to switch off your microphone. The content of the webinar is provided for information purpose and is not legally or contractually binding, except otherwise stated. The information provided by the speakers and experts are provided in their personal capacity and do not necessarily represent the official position of the respective affiliation. Just to ensure there is no misunderstanding, to ensure that everybody feels free and to discuss and to share ideas and visions. So let me start by giving the floor to Malte, if you agree, to start with the introduction to the Data Act, to the main obligation. What is the Data Act? So we'll have a first part of the webinar, as previously announced, really focus on what is the regulation, what does it imply, clarifying the norm. If it's fine with you, Malte, I give you the floor and I let you can share your screen if you have some slides.
Yes, I'll push myself into the screen. Just a second. So this be probably in full screen mode. Let me see if that works. Can you see the slides well? There's always a little thing with Zoom that I'm...
Yeah, it's for the time being, it's gray.
Why is it screen sharing paused? I wonder. Resume. Let's see. You are sharing a screen, but then
No,
I
we
can't.
see. Yes.
But if I do the full mode, that's something where I'm always struggling. When I do the full presentation mode,
Okay.
I go into something gray. Doesn't matter. I'll take it this way. Apologies for this. And I'll try to just minimize the sidebar as much and move this up maybe.
It's a gray area. Yes.
This one,
Yeah, on the left. Yeah, no, it has been reduced.
It's because I'm not in the presentation mode, because that somehow doesn't really seem to work. But if you see this, the Data Act, very good. So this is the main 5 areas of the Data Act. I will focus myself today on the upper left side, the portability of IoT data, which is probably economically speaking the most far-reaching one, where there are the most compliance needs because it concerns a lot of manufacturers of a lot of IoT products. Then we have also the economically secondly relevant one, which is the second to the right, easier cloud switching, also a big business, where we have Chapter 6, we have the switching between cloud services. I'm not addressing this because we have investigated with the partner team that did this chapter with us in the Data Act that there is already in the CISPE association, CISPE, an endeavor to make a compliance regime. So my advice first would be to focus also your endeavor on Chapter 2/3 of the Data Act, which is this portability of IoT data. It's a lot already, and I think what I've seen, well, no, actually your current draft goes a bit further, but we can maybe in a follow-up exercise see what the CISPE certification does and what it doesn't do. We then have, because also these are, if you want, partially publicly enforced and sanctionable parts, which is not true for the top right, which is Chapter 4, which is setting a regime for contractual fairness control that we have for consumer-facing contracts that you know, and to a very limited extent currently for business-to-business contracts in the agri-food supply chain and on late payments. And the Data Act for data sharing clauses in contractual agreements unilaterally imposed now also has a fairness check consisting of the three elements: general clause, blacklisted terms, and the gray listed terms with a margin of appreciation to the judge. Here it's private enforcement, so that's judicial enforcement. Not sure how far this can go, and I will not tackle this today either, so that's why I'm spending a bit of time in this introductory one. And then we have the final one, which is chapter 5, which is the second to the left, where we have a quite narrowly focused framework for businesses that could be requested to hand over certain data to government authorities in emergency situations and situations that align to this. This is also, I think, when I'm now putting myself in this question of when are you complying with the Data Act, there is, I don't think, much to comply with other than that you have to be ready to receive and treat such requests. But the definition of what data for what purposes will be requested, that's determined by the governmental authority that will send you the request and say, I need this data for this purpose, and I'm justified because I have an emergency and it's declared public emergency in this region. We have a wildfire, or we have a flooding situation, or something similar. So also very hard to comply, which brings me then back to my upper left, which is the portability of IoT data, which is complicated enough. And just to set the scene for those who have never heard about the Data Act, it sets a simple, seemingly simple rule, which says if you own or you rent a physical object that generates data that can be read out either physically on premise or over distance, over the Internet of Things if you want, then you in principle shall have access to the data you generate. However, limited to a raw data, and that's already one of those gray areas where compliance is rather difficult, maybe it's also to define, because we have used a lot of terms that are can be filled with interpretation by case practice. And it's data that someone else has. The assumption goes that some of the larger industrial objects are designed often or normally in a way that the operator can directly read out as part of the functionalities and features of the object. He has access to certain data that is the object is designed for, and gets explained how to read out the data. That's something where the Data Act doesn't even come in. This is just the status quo. You have your object, it gives you certain data. What the Data Act now tackles is the second situation, is when the operator of the machine does not have factual control or access on the data, which means that someone else, we call this entity the data holder, holds data from your asset, from your machine, as a consumer, as an industrial professional user, and you are now given by law the right to request a copy of this data and also request that this data be ported to a third party of your choice. That's the Data Act. And when the third parties receive the data, FRAND conditions will be applied. Again, the question, how to measure compliance with FRAND. Are your conditions FRAND, fair, reasonable, and non-transparency? The easiest is my last bullet point, is a transparency obligation. As a manufacturer or data holder, I have to be transparent. Who else, other than the operator of the engine, of the machine, will hold data, will receive and hold data from the IoT object, from the connected product? And how am I going to act? How can I request access? This has to be explained at a certain level of granularity and detail. Voila. So we have a regime where you are compliant if you have built certain technical interfaces that make it possible that you have compliant with the transparency obligation, one, and secondly, with the technical obligation to have an interface possible for you to request your own data as operator, and for a third party to also receive it based on the instruction. But now all of this, and this is now the complicated part, subject to also maybe competing rights on the same data asset. That's the really complicated thing with data. Data can can embody many things. They can be personal data of one person only, of several people at the same time. They can embody trade secrets. They can embody copyrighted content. And depending on what is encoded in the data, there may be competing claims on the data. We are excluding copyrighted content that's said somewhere in the recitals. We are obliging you, when you make available data, that you respect the GDPR, that you can only transfer personal data when it's compliant with the GDPR. And that begs also the question, what do you have to know about the other party? Can you just give personal data to the other party? Is it beyond the purpose? Does this other party have a legitimate right? Does he have a purpose to receive the data? And then the final thing is the trade secrets part. These may be your own. That's where most of the contentious discussion was, that the manufacturers say, well, these data are my trade secrets. And the Data Act, I think that makes it also so interesting, now provides for mechanism to balance out especially this competing claim of the trade secrets as opposed to the obligation to provide access. And the way it's designed is that the data access, in principle, you should not lose the quality of a trade secret when sharing. So you can actually design, if you think that the data that the user generates, the raw data that the user generates by operating a machine, constitute a trade secret or can reveal a trade secret through an analysis, a smart analysis by an algorithm, can reveal construction and design choices that you made that you otherwise are not exposed or not generally known and kept secret by you. Then you can invoke a number of mechanisms, layered mechanisms, to either oblige the other party to take certain additional security measures, not to share onwards, and to keep it safe, or even to stop it. That's also, I think, an interesting feature of this Data Act, which tries really to regulate the competing claims on it. I'll then say just also that we are currently a lot in conversations with manufacturers, what complied. So we receive a lot of questions, and I'm not going to answer any of these, but we have an FAQ document. Sorry, I maybe should just give you a chance to get a gist what we're typically getting, but we're getting like, I would say 20 times the amount of these questions, very detailed sometimes. So we have condensed many of them, and that's maybe already material also for a really fine-grained compliance, also our FAQ document, which we have just recently updated again, and which we're already working on the next version because there's a lot of questions coming in, and we have a certain bandwidth to discuss in the team how would we publicly reply to them in a written form. And so there's more coming also maybe for your future work to consider this living document. There are a few really very, very important ones. We can maybe go through different aspects. That's maybe also a question what you're expecting from me here today on this webinar. There are some things that are coming super often. I can go into these. Also in this one about, is there really a design obligation, or what do we mean? But there's also now a question number 22 in our FAQ that elaborates on this in more detail. Or things, what is really in scope, which are the data in scope, what is the data from, what is a related service, So there are now many things I could give to you. I may maybe bring it back to your hand, Sebastian. But before I do so, and before I close this maybe short intro, I wanted to share the thought that I wonder how it resonates with you, because ultimately this regime is a competition enabling a competition law regime, which builds on the idea that for certain IoT data, for certain data from connected products, we have this monopoly gatekeeper data holder. If I take the example, the known example is automotive, and here, well, also conversations may be started. The car manufacturers insist that either the data stay only in the car and no one reads them out, or they go to a backend cloud-based server solution from which on they, the car manufacturers, enable access, which puts them in this gatekeeper, monopoly, access provider situation, which we want to break up by obliging them to allow the user to receive his own data and the user to direct the data flows to someone else. And also actually obliging the manufacturers to ask the user in case they, the manufacturer, want to share the data onwards to another company. That also has to be actually agreed. It can't happen behind the user's back, because we want this transparency and control over IoT data. But in the end, the contours, as I said it earlier, what is really in scope and what's outside scope, that's really an engineering question. It's really complicated, and we are receiving a lot of questions, and we're sitting with a lot of industries, and they're giving us a lot of kind of hints, because we're having this notion of raw. Well, first we have this notion of, sorry, I'm gonna just kill this thing here. We have this notion of raw, but because we want to avoid that data resulting already from algorithmic processing are also covered, because we want to preserve the investments in this algorithmic processing and the ingenuity, not only because the results otherwise would be free, but also people could reconstruct the algorithm if they really are ingenious. We have also the notion what is really readily available. I mean, sometimes it's not so clear. Sometimes the data are not already on the server of the manufacturer or the data holder, but they could be very easily, or they are already long-term archived on the server of the manufacturer, but it's very costly to bring them back. So what is readily available? So there are a lot of these terms that where I think the engineers especially are now sitting and scratching their heads. What do I exactly have to do? And that's where I'm wondering. Then the other thing is really also, it's a demand-driven thing. So users and third parties will ask for data, and you are compliant in the best scenario if you are satisfying these user or third-party requests. But the user requests obviously are framed by certain conditionalities, what they can ask for, but it has to be raw, has to be readily available data, and things like that. So I'm also discovering maybe with you the function of the approach you take to compliance verification. And happy maybe now to give it back to Sebastian to maybe guide me on more specific questions, or from the audience.
Thank you very much, Malte. I think it was a very good initial introduction. Maybe for the audience, could you clarify so in terms of territoriality? So for instance, who is supposed to comply with this obligation? Does it apply to only European companies? Does it apply to companies located outside of Europe but providing services to Europe? Maybe if you can just, for the audience, clarify a little bit the scope of the application.
Yeah, with pleasure. I mean, that's a simple one. We are considering the Data Act to be internal market regulation. So we are leaning to the new approach, which means that we can refer to the so-called Blue Guide, which DG Grow is constantly updating on what the concepts mean, making available on the market for products and services. So it's the question is the product or the service available on the European market, and has it been brought to the single market? And if it is, it's covered, and if it's not, it's not. So it doesn't matter where it's been manufactured. It's matter whether it's been introduced to a European market. And then you have obviously the complicated cases with the mobile objects, and that's trains and planes and vessels. And it's for vessels, it's extremely complicated, we learned. But happy to, if you have a specific product category here in the group, happy to also take that question.
We initially discussed to have several presentations from your side, so to engage in the description of the Data Act obligations for SMEs. Do you want to, do you have another presentation to dive deeper into it, or?
Sorry, I was just checking that I could also manipulate. No, I don't have something specific for the SMEs. We have in the, and I should have done that in the presentation, that we have the following for this chapter 2. Again, we try a number of reduction of burden, if you want. So we exclude in Article 7 from the scope products manufactured by small enterprises. And then we have in Article 7.2 a transitional exemption for the medium-sized enterprises, I think, where they have been active on the, where have to become a medium-sized enterprise for only a year and the product is only available on the market. So there's a transitional provision when you grow from S to M, that you are also temporarily outside scope as manufacturer of these products. That's what it is. On the reverse side, if you are now the third party that wants to access data from IoT objects manufactured by the larger companies, by those in scope, we have a charging rule which reduces the compensation that you owe to this data holder to the mere cost of making the data available to you as the SME. That's in Article 9. And I can say that we probably will expand this even. You may have heard of the idea that small mid-caps, so that's companies until up to a size of 449 and market capitalization, which I forgot. There's an omnibus package coming soon. So there is also, soon there will be action presented to expand certain benefits for the SMEs to the small mid-capitalized companies. That's essentially what we have on SMEs as the advantages.
As a general guidelines, if you would, what would you recommend to SMEs or larger companies to focus on in terms of compliance, in terms of priority order? What would be, according to you, the most important element to be checked by a company to ensure its compliance with the Data Act?
What we're saying often to companies is to start off with a list of data sets that they for sure have, if they have them, so that they provide a minimal list. So to say, how can I maybe phrase this better? So the first thing obviously is to check, do you actually receive data from your objects? Maybe you don't. Second question is, do you receive data that identify individuals or the object? I mean, that's already a question. Does the processing happen on the edge? And will you only get, and how do you get data back in terms of them being anonymous? Will they be for a split second identifiable because the device ID will be communicated, but then very automatically before anyone actually has a chance to exploit the data, the device IDs are being taken away, then the data are outside scope. So the first step is actually, do you have data that identify a specific connected product? Because I should probably have said it, it doesn't matter for our purposes whether the data are qualified as personal or non-personal under the GDPR, because we also have the robots and the tractors in scope that are operated by legal entities, maybe that are owned by legal entities. Obviously, almost always operated by a human, but maybe the human is not even identified because he's just pushing a few buttons without being identifiable who has pushed the button here. So that means you have readily available data, and then doing a second, the second step is what is the level of rawness of this data, and can you make some of these available? This is the one cluster. The second cluster is actually if I have any of this, do I have already a mechanism to distribute the data? Just any mechanism at the moment. Can people log on? Can people create a user account? Can they identify themselves as the lawful owner or otherwise the operator of the machine through QR codes on the object or other means that allow also the data holder to be sure that this person really is running, operating a machine and lawfully. That also means not only having like a web API, but also a mechanism in place that allows users to identify themselves as lawful users. That's maybe the second and separate step, which is for the owners maybe relatively easy. But then if you think about objects that may be rented out rather frequently, that's for the car industries and the leasing firms and the rental companies, this is a huge question that we're discussing. How do I actually, what is my mechanism to know who is currently driving the car that I produced? That would be the second one. And the third one is, and that's probably the simplest, is the Article 3.2 and 3.3 obligation to be transparent, to have a good description of the data that would be collected from the device and available to the user. Maybe I stop it here.
Yeah. Let me maybe, I think you mentioned something very relevant by clarifying that Data Act does not apply only to personal data, but applies also to, let me just see, just bringing back an image for the background, but applies to non-personal data. Perhaps one element which can be relevant for the audience that, as it was mentioned by Malte, IoT device do not necessarily contain or collect personal data. So you can have, for instance, a temperature sensor per se is not considered as a personal data, a source of personal data. I mean, if it's ambient environment temperature sensor or weather station, you can collect a certain number of data which are not considered as personal data. However, from DigiJustice interpretation, and I will speak as under the control of Malte, you have data which sometimes do not look as personal data, but which are considered as personal data. For instance, IP addresses are usually by default considered as personal data if they are corresponding to the IP address of the user. Similarly, all data collected from mobile IoT devices, when I mean mobile IoT device, I refer to devices which can be attached to your pet or to your car, or devices that you can bring with you either in your private life or professional life. These data are considered as personal data because they are considered as providing information on the activity of the user, even if the data may look distant from personal data. So it's always very important to carefully analyze the qualification of your data as personal or non-personal data to ensure compliance with the GDPR part. Of course, for the Data Act perspective, this has a limited impact, but from the consent or lawfulness of the processing of the sharing of the data with a third party, this may have a huge impact. I don't know, Malte, if you want to complete on these or to add more details on this aspect. Maybe the interplay between Data Act and GDPR.
Yeah, I mean, this is problems that we couldn't really solve, giving greater clarity on when IoT data would be anonymous, yes, no. baseline of the conversation was really the GDPR remains the prime locus for that discussion. I mean, we also see the current court judgments, the SRB case, maybe coming and delineating clearer when is something anonymous, when is it not anonymous, which is why we chose this option to not make this a category, or that doesn't make this criterion relevant for data being in scope or not in scope of IoT data. Because also sometimes it seems counterintuitive, and also we wanted to make it in a way also jurisprudence proof to say, well, if now someone comes along and says, well, tractor data are never personal data because actually they are rarely used in the private capacity, but they are really a professional tool of a commercial endeavor. Yeah. So this doesn't matter. Maybe something, I don't know how this question and answer tool functions, but I just answered a question that is probably of interest to many in this question answer function. I don't know whether everyone can see the answer, but it was a question answered asked by Vincent Robert or Vincent Robert on the model contract terms, which is and standard contractual clauses. So we have this task as commissioned to elaborate two sets or several sets of contractual clauses, one set around Chapter 2 compliance and one around the Chapter 6 compliance. And the Chapter 2 compliance, we call them the model contract terms, and Chapter 6 compliance, so cloud switching, the so-called standard contractual clauses. The choice of terms actually means, the difference means nothing to me. At least I have not understood why they have a different terminology. There's an expert group that was drafting this with really good, very good academic and business experts. The final delivery of all the sets of the terms is, to my understanding, the 14th of March, when the expert group closes its work. It has done one webinar per each set in November, that sparked quite some interest. To my knowledge, there is no other intention to consult the general public or the informed public on these sets. That's a choice I personally would regret, but that's not in my hands. The Commission will now look at these contractual clauses and transform them into some sort of guidance. I think for your process, especially as you will go along, it might be good for you to receive at least the sets. I can't promise now that we will publish them widely or circulate to everyone in this call, but maybe to you, Sebastian, and then you can involve whoever you think you know of. I think we can certainly, well, I don't know, I will check with my colleagues, but I think it would help your work for sure to see the model contract terms.
Yeah, no, that's very interesting. And by the way, it could be, if I may make a little parenthesis, there will be dedicated sessions at the Privacy Symposium on the standard contractual clauses, and to see the convergence on one hand internationally with all the regional STCs to support some convergence in this field. But I think also to support convergence or evolution of SCCs to address the different data-related obligations or regulations, which can be an interesting exercise to simplify the work and the compliance of the different controllers and processors in Europe.
There's another question. I don't know, maybe can people take the floor or otherwise from Vincent?
I think, we can probably.
It reads, we will need a DSA, and I'm not sure what a DSA means. It could be a digital services act in my world, but probably needs something else. It's been taken by.
I moved it.
Vasiliki.
I moved it to the answered one so everyone can see the question as well.
Yeah, very good. So I need the decryption for the acronym DSA from Vincent, maybe.
Vincent, if you could just complete, I think maybe I can give the floor to Vincent if you want to speak. Vincent, you have the floor. You can speak.
Hello, can you hear me?
Yes, we can.
Hello, nice to meet you. Thank you so much, Malte, for your intervention. That's really, really interesting. Yeah, we were wondering whether a data sharing agreement or something like that was required when a public authority asks for data in a non-emergency situation.
What do you mean when you say data sharing
Data
agreement?
sharing agreement, I would say something like the MCT, but specific for the public authority, something to formalize.
What we have foreseen in this chapter 5 is that you get basically an administrative order, if I can put it into a plain English term, that the government authority would formulate a request, say, hello, dear company X, we are very certain you have the following type of data. We would need it for purpose X. It's linked because of the purpose being in Article 15 of the Data Act. And we will keep it for so long. And a couple of details. The Commission actually has the interesting task to set up a certain kind of template for these requests. No one is working on this at the moment here. What would the template basically have to contain? So the nature of the sharing is not so much like a civil law agreement, but rather an administrative request with promises to do certain things, to delete the data at a certain point, not to give it to other public, to stick by the. So there are certain things that are actually laid down in chapter 5. So it's not an agreement in the civil law contract times. That's why I was maybe struggling with the DSA term.
Okay.
Perhaps one element which is raised by Vincent is that if part of the data, let's imagine a situation of COVID emergency, and you have personal data, under GDPR, you need to have this data sharing agreement between controller processors. And I think maybe it's also related to this. In the case of personal data, we can expect that there is that the required provision of the GDPR will be integrated into the standard request sent by the authority.
Yeah, there is also, if we now really go into the fine print of chapter 5, there is a distinction between, I now need to look up the term myself, and maybe I can even project it for everyone to see, that we see the difference, because it's probably instructive. Replace current share. Okay, I can maybe try that and then go to the Eurolex and share here. Wait, I need to take out a few things here. We have in Article 15 of the Data Act these are the grounds for which you can have data. So we have ground A, the response to a public emergency. And then we have grounds B, which are the production of official statistics or mitigation or recovery from a public emergency. And the cumulative second condition, that you have exhausted all other means to obtain such data on market kind of conditions. However, and now I'm looking at the provision for these situations in 15b, you cannot have personal data. And this is somewhere explained later on. I haven't spoken about chapter 5 in a long, long while. So it's really only for the 15A situations, also to just make this really clear. That's really when you have to respond to a public emergency. And for that situation, we found the construction, and I need to look back at the recitals where we're saying the GDPR legal obligation, Article 61C, is the combination of Article 15 of the Data Act with the national measure declaring the public emergency. I think this was the compromise, well, the kind of formula we found, that this together forms the obligation to which a controller is subject to. No, or allows it's not 61C, it's 61, the permission of the public sector body to process data. I've forgotten now the number, but you know it probably better. And this is somewhere explained in the recitals. I haven't spoken about this for long, so I can't find it back by heart, but please have a look in the recitals of the Data Act.
Very good. Do we have any additional open question? We have another question regarding personal data. Do I understand correctly that EU Commission qualifies all data that is collected by a mobile device, wearable, as personal data, including, for example, battery status of the device if it was collected in context as used by a specific user? Because applying the NOAC test, for some purpose, I am of the opinion you can argue that battery status is not personal data. That's a very good point. Again, the discussion we had already in the past at several opportunities with DG Justice and this interpretation of personal data generated by mobile IoT device, that it's not that it is definitely in all cases, but there is a presumption that if you have a mobile IoT device, which is linked, which will follow a human activity, including, for instance, your pet. You have a dog and you have, let's say, a GPS locator of your dog. As we anticipate that a user may be walking his dog, then it will become personal data because there is a high probability that the data you will collect will give you some information on a specific natural person. Now, of course, you may have cases which are opposite, but then you will need to demonstrate. You will need to have a clear evidence to demonstrate. The same example for an IP address. IP address by default is often recognized, generally recognized as a personal data, IP address of users. Now, if you have IP address of internet cafe, and this IP address remain the same regardless of who is using your computer, you can still argue that these IP addresses are anonymous. Or if you have IP address on of a switch or a router, these can be considered as non-personal data. But there is, I would say, a default appreciation of the quality qualification of personal data to consider that data generated by IoT device should be considered as highly likely to be personal data due to the fact that it will follow human activity. Yes?
Yeah, I confess I don't know the NOVAC test. Also happy if the participant wants to come in. What we were, the way the discussion went in the house was if the device is in a electronic register, obviously, linked to an identifiable individual, we would be safe to assume that the data that the device produces are personal. Now, it may be that there is a mobile device that is not attributable to an individual because it's something shared that is not, that doesn't have, but I find it a bit hard to imagine a type of a device that is not linkable to an owner. But maybe you have an example.
I would say a good example could be a weather station.
A weather station?
Yeah. So you have an IoT platform on your house which measure the temperature or the climate, the atmospheric pressure. Per se, you cannot really connect this data, even if it's on the house of a user, but you cannot connect the data set to a specific user because this is something common to the environment. But I agree with you, it's important to be very careful and to be very cautious before considering data as non-personal data.
Yeah, but I mean, the situation that we're considering in the Data Act is that someone else holds the data from your weather station.
Yeah.
And if this someone else knows the ID of the object and the person that is registered as an owner or purchases or anything else, we are in the realm of personal data, aren't we?
Yeah. Mm-hmm.
But I'm happy. I mean, this is interesting. I mean, I really encouraging the anonymous attendee to become to de-anonymize herself or himself, and bring an example where this would not be the case.
What I would suggest, we can continue answering the Q&A at the end of the webinar. So if you have more questions, I see another question from Vincent, but maybe let's go through the rest of the presentation, and then we can take additional Q&A at the end. Or maybe if you want Malte to answer this last question, so we can still address it regarding compensation of the user.
I'm reading out the question so everyone has it. As regards the compensation to the user, is the compensation of the user for the mere use of their data by the data holder and application also between companies, or can it be excluded? Now, the Data Act foresees a compensation of the data holder by the third party of the choice of the user. So again, the triangle goes, a car maker holds data from my car. I am the user. I am entitled to get the data I generate from my car for free, no compensation. But if I want to give it to a service provider, a car repair service provider, and I tell them, please consume third party directly from the API of the car manufacturer, the data holder, the data, then you, data holder, car manufacturer, you can charge the third party a compensation. That's the compensation we foresee. If the data holder, in this example, the car manufacturer, compensates me as the owner or driver or holder of the car, that is another matter. That is not regulated by the Data Act. That's indeed the whole question on, why are big objects becoming smart? What's in it for the manufacturer? Is the sales price covering all of this? Is there a mixed calculation, as it's often the case that the car manufacturer or the holder speculates on the use of these data for other things? And that's then would be also the compensation. Is that, maybe, I don't know whether Vincent's microphone is still open and he can just explain.
Yes. Sorry, Malte. Yeah, I was referring to the fact that the user is supposed to keep control over the data generated by his use, and I understand that even the data holder cannot do certain usage of those data. For instance, transferring it to third parties without the prior approval of the user. And my understanding was that even, well, I would need to understand whether the use of this data by the data holder would, by the law, impose the authorization of the user and therefore a compensation to the user for the use of the data generated by the user, but used by the data holder.
Yeah. No, Article 413 only says you have to contractually agree. But what's the quid pro quo? What's the compensation? That's not regulated, because indeed, and that will a lot depend on the market situation, the market power situation of the manufacturer. How strong is he or she to impose these kind of data usage clauses on the purchaser? And can you say, well, if you don't, it's conditional for buying my car that I will do certain things, as we all have learned it with Microsoft. If you want to use M365, you have to agree that certain data will just be used for product improvement purposes and God knows what else. And we have no real negotiation power. And then there will be other machines when maybe it's even the opposite. You have a small manufacturer and really few big guys, and they will dictate. Then you have to just give them whatever they tell you. So they say, well, you will not receive any data, which is very much also actually, by the way, in the supply chain, the upstream suppliers, they don't have any rights typically. That's a problem as well.
Mm-hmm.
Okay.
My question was related, in the draft MCT that we found, we know that it's not the definitive version. There's an Article 6 which states compensation due to the user, and there are sections where they tend to say the data holder undertakes to compensate the user for the waiver of user's rights in accordance with specific clause or for the right of the data holder to sell the data, or for the use of the data in accordance with clause 3.1. And it seemed to me that those MCTs, or as a draft, tend to provide with this framework of compensation of the user by the data holder in certain situations. That's the reason why I had this question.
Yeah, the reason why they have it is because it's obviously an option that you can agree a compensation. But when I put myself in the shoes, I mean, that's now at the second level also the complication with this regime, because it's okay at the first instance. At the first sale, you can say, well, if you don't want to, I want, as a manufacturer data holder, have data from you, and I will sell you the object at this price, but conditional that you agree to share some data with me. I could also give you contractual options. Okay, if you don't want me to have data from the object, we'll just increase the price. So you differentiate the pricing at the point of sale. It becomes a little bit more complicated once the object has been handed over with subsequent users, because they either have to follow the chain and say, okay, the initial condition was that the manufacturer always receives certain data, but a second-hand user cannot now overturn this, because that is a bit of flaw of the construction, if I can also say it. But with the MCTs, we give this option because it's an option to say, I will give you a reward. But it's the question whether this is part of the purchase price deal already, or whether this is a separate. This translates into a sort of a discount. If you agree on this, I'll give you a discount on the purchase price. I mean, we will have to see what the pricing strategies of manufacturers will be in light of this new obligation.
Thank you.
Thank you very much. Very good questions. What I would suggest now is to continue the presentation on how can you then assess compliance with the Data Act. I will start by a short introduction on, again, the process, the genesis, and the context in which the criteria for the Data Act have been developed, and then we will dive into the Data Act criteria themselves. We'll start by a brief introduction, then Vasiliki will complete and present the specific Data Act part. So as already mentioned at the beginning of the webinar, the European Center for Celebration and Privacy is mainly focused on supporting the transfer of research results to the market, and in particular research and innovation to support regulatory compliance and certification. So working closely with quite a number of European research projects, with the different authorities, regulators, with the different stakeholders, and then we make the schemes available to qualified third parties, so either certification bodies, law firms, consulting firms, solution providers, and so on. So it's very much about regulatory compliance, and that's something I saw a little bit distinct from traditional ISO standard approach, in the sense that usually on with ISO standards, you focus on a set of principles that you will collectively agree on among experts, and then you will use this standard, which has been collectively co-created by experts, as a reference for certification. While in the case of the European Center, we focus more on how to translate the legal obligations into auditable criteria. So it looks a little bit the same, but the focus is different. It's very much focused on how to enable companies, SMEs, or public administration to assess their regulatory compliance with a given regulation. We are mainly working, so we're working on different aspects, not limited to it, but the European Center is working mainly on the EU data-related regulations. So you have an overview of the EU legislation in the digital sector, with regulations which are already in force, those which are in the process of being adopted, and those which are planned for the future. But as you see, it's a quite complex landscape in terms of regulations. And what we try to do is to ensure that you can provide for the most relevant ones adequate criteria or solutions to support compliance. Again, the idea is to ensure that if there is an obligation, we can help the different stakeholders or the different actors to comply with it, and to make make this compliance as efficient as possible. We, as you all know, we have been leading the development of Europrivacy, which has been approved as European Data Protection Seal by EDPB under Article 42, and which is a formal certification under the GDPR. In the case of the Data Act, Vasiliki will come back to this later. Contrary to the GDPR, there is not a formal certification mechanism in the Data Act, but still the idea and the possibility to enable companies, public administration to assess and certify the compliance make a lot of sense. And so in terms of risk management, in terms of communication to third parties, to build trust, and also to value the compliance. And we'll come back to this a little bit later. The way the European Center handles certification scheme that we have, in particular for Europrivacy, a dedicated international board of experts, with experts from all over Europe, including experts in data regulation or legal experts, but also data experts in certification in cybersecurity, who overview the scheme and ensure that whenever there is any jurisprudency or evolution in the regulatory framework, they ensure that the requirement, the criteria are always aligned with the legal obligations. The European Center is established in Luxembourg, and as we mentioned before, ECCP is really acting as a SDO, standard development organization. It does not deliver certification, it does not deliver consulting services. It's really focusing on developing the different standards, tools, solutions, and making them available to third parties. So we have European and global ecosystem of partners, official partners, including certification bodies, so the largest certification bodies, law firms, consulting firms, solution providers, and other third parties who will then use the scheme to make them available to the market. And we have, of course, also companies or public administration which are directly using the norm, the standards for their own use as internal resources. Very good news, recent ones, which is will be published in the coming days with the European Research Agency. We have been working on an international version of the European Seal named Interoperability, which is aligned with different regulations. And these Interoperability was just approved by International Accreditation Forum a few weeks ago, a couple of weeks ago. We are now in the phase of announcing it and publishing it. And that enables to use a set of criteria to assess compliance not only with the EU GDPR, but also with the Convention 108 plus, the Global CBPR, the Malabo Convention, the Asian Framework of Data Protection and Privacy Requirement, the Ibero-American DPPS or PDPS, and also, of course, aligned with the EU-US DPF. So the idea is to, again, facilitate compliance to ensure that if a European companies, for instance, wants to ensure compliance not only with GDPR, but is active on the global market, to easily get a complementary certification to demonstrate compliance, not only with the GDPR, but more globally with the main data protection regulations. Then very early in the research, we identified the possibility to leverage and the European Seal to propose extensions. So we have been working on quite a number of regulatory extensions. We already have a certain number of extensions which have been published, like criteria, dedicated criteria for the e-privacy directive, the Data Act, we're presenting it now, the Data Governance Act, AI Act, DORA. We are currently ongoing work on these two, Cyber Resilience Act, DSA, EHDS, and other regulation. We are likewise working on extension to national regulation like Swiss FDPA, the UK GDPR, the Californian CCPA, the Brazilian law LGPD, and so on. And the idea is, again, to enable those who are using this criteria to assess their compliance, their conformity, to be able to extend the assessment of the conformity to other regulations or to other either European regulations or national regulations. One of the extension is the extensions which has been developed on the AI certification. And now I will pass the floor to Vasiliki to present the dedicated extension on Data Act criteria, which is now available on the Europrivacy community website. Vasiliki, the floor is yours.
Thank you very much, and thank you both to Sebastian and Malte for the wonderful introductions. Now that the Data Act requirements are a bit clearer, I will be giving you an overview of the work we have been doing for the development of a Data Act extension to assess and certify compliance with the Data Act. But first of all, I would like to take a moment to give you more insight on the genesis of the idea behind the Data Act extension, as it has first been developed in the context of the European Research Programme, in particular in the context of two projects that you can see here, AD4GD, aiming at the establishment of a data space pursuant to the Green Deal, and SLICES, aiming at the establishment of a research infrastructure for large-scale experiments. In both these projects, and the main common denominator is the fact that sharing IoT-related data is very important for both of them, and thus arose the need to facilitate compliance with the Data Act. And after this small introduction, I think I can move on to the Data Act itself. So the Data Act extension is meant to assess and certify compliance, of course, with the Data Act requirements every time that connected products and related services are involved. And as you can see, this documentation has already been published. I will delve a bit deeper into this in a moment. But for the moment, I would like to pause here a bit and give you a short overview of how the criteria are structured, also leveraging on the knowledge that we have acquired in the context of developing Europrivacy. So as you can see, every criterion has already a unique reference identifier in order to facilitate tracking the criteria and assessing compliance, and of course, a dedicated title and the requirements. But as you can see here also, each criterion clearly indicates the applicant category for which it is applicable, as well as the legal reference behind the requirement. In order to further facilitate compliance, each criterion is further accompanied by implementing guidance, providing more details about how you can comply with its criterion requirements, and the suggested means of verification, meaning what documentation you can already prepare or provide in order to be able to be certified. That being said, the main question behind it is, who are these criteria relevant for? And I think we can move on to the next slide. So, applicants for the Data Act extension can be any of the stakeholders involved in all of these procedures, including, of course, connected product manufacturers, connected product service providers, data holders, data recipients, including third-party data recipients, and data and services users. As I mentioned previously, the applicability of each criterion for each of these applicants is clearly marked, so you do not have to guess which is the case for each criterion, and of course you don't have to go back and read the Data Act necessarily for each criterion in order to figure this out. So the Data Act criteria are actually divided into further sections to facilitate the assessment and auditing, starting of course from the provision of some general obligations which are applicable beyond any specific case. And then they are moving to more specific thematic topics, including connected products and related services data sharing required by EU law, business to government data sharing, and then specific requirements for trade secrets and database rights, switching between data processing services, the lawfulness of international governmental access and transfer of non-personal data, interoperability requirements, the use of smart contracts for data sharing agreements, and requirements for unfair contractual terms, or better, to avoid unfair contractual terms. So I would now like to take a moment to explain a bit more about how the Data Act extension works and how you can choose to pursue it and get certified. So the Data Act extension can, of course, be used as a complementary certification to an already existing or upcoming Europrivacy certification if you choose to pursue GDPR certification, or as a standalone certification. This means that you can either pursue both a Europrivacy and a Data Act certification if that is deemed necessary from a company perspective, or as a standalone certification, and you can just certify under Europrivacy, of course, and under the Data Act alone. As I mentioned previously, the Data Act extension and the related documentation has already been published, and you can find it to the Europrivacy community website, where you can also monitor any other changes or upcoming updates to the existing documentation. But of course, you can also benefit from the entire Europrivacy ecosystem and online tools and support in order to make your compliance more time and cost efficient. This means that you can visit the Europrivacy public website, where you can find more information about how the scheme works, who are the partners, and other valuable information like this. You can also get training on how the scheme works in practice through the Europrivacy Academy website. And of course, you can visit the Europrivacy community website, where you can also access the Data Act extension criteria, but not only that, but also much more additional resources in order to support your compliance activities. Now, the scheme is actually supported by a trusted network of official partners that you can also find at the Europrivacy website. I think we can also move to the next slide. Yes, perfect. Who you can either contact directly if you wish to get certified or request assistance with the preparation for the certification procedure, or you can contact us and we can bring you in contact with the partners that are more suitable in order to assist you. And as I mentioned, all of these partners are available online, so you can easily find them and see which ones are officially recognized by Europrivacy, and of course, which ones are accredited in order to be able to deliver certification. That being said, the official Europrivacy partners are divided into further categories, let's say. We do have some partners that are there in order to assist you in your preparation to get certified. And then we have some partners, of course, that are providing technological solutions in order to facilitate compliance. And finally, we have the partners that are there in order to deliver certification, the so-called certification bodies. It is worth highlighting that only the certification bodies that you can find on our website and are accredited by accreditation authorities are in the position to deliver certification pursuant to either Europrivacy or to the Data Act extension. After that point, the certification journey is actually simple and comprised of simple steps, I would say, with the first one, of course, being complying with the requirements, and then moving ahead, checking and documenting your compliance in order to be able to reduce risks. And of course, certifying, which brings a lot of added value. I will explain a bit more about the added value in a bit. And of course, then maintaining compliance, where you just have to make sure that you remain in alignment with the requirements of the legislation and the criteria, of course, and you can simply enjoy and benefit from the additional value. You may still be wondering, however, why you would certify and under the Data Act extension or Europrivacy itself. And I would like to provide you some more information regarding the additional advantages that certification brings.
Maybe just a compliment regarding the journey. What is quite interesting, that's something we noticed through the research, that indeed most of the effort is done before the certification process starts. Because anyway, companies need to comply with the regulation. And what the certification does is fundamentally to check and validate that you are indeed complying with the regulation. So what is also very interesting in the process, before giving back the floor to Vasiliki, that you start the effort curve is most of the effort is done before you start engaging in certification. You still have some work to be done, but it's a minor effort compared to the effort to comply with the regulation. And then what is very interesting in the process for companies, in particular for companies which have to be careful with their resources, cannot afford to spoil internal resources. There is the fact that you already have a return on investment while you are documenting your compliance, even before being certified, by just using criteria, documenting the compliance of your data processing with the criteria enables already to reduce substantially the risks. And then the certification precisely enables to value your compliance, so to be able to communicate it, to be able to build trust with third parties, and to demonstrate to third parties that you are indeed complying with the regulation. And another element which is important to mention, and Vasiliki will come back to this a little bit later, that certification from an accounting perspective is an asset. It's like a pattern. So it's also a way to really create intangible assets for your company. If you're a company, for public administration, of course, this is maybe less relevant, but it's interesting to notice that it's really not only, I would say, from a perspective or perception perspective, a source of value creation, but it's really real economic value creation, a way to ensure competitive advantage in some cases for companies, or to but anyway, to have a recognition of the compliance, to translate the effort which has been invested to comply into something that can be economically recognized.
Perfect.
Vasiliki?
Thank you very much for the intervention. So yes, as Sebastian mentioned, and as I would like to take a moment of it to describe right now, certification brings a lot of added value into your compliance activities. And this starts from the very basic element of identifying and reducing your legal and financial risks. Because if we all know that if you do not comply, this brings on, of course, a lot of legal risks, but also financial risks in case this is further pursued in terms of either a civil lawsuit, for instance, or a fine by authorities. The additional point is that through the criteria and the way we have developed the criteria and the scheme itself, you are able to check and demonstrate compliance. You're not simply doing a window exercise in that sense of just going somewhere and having the certification and saying, oh, I am certified, but you actually delve deeper into your compliance activities in order to make sure that you are actually compliant in a way that can also be further audited by third parties. And of course, this brings additional value to your reputation and access to the market. Additionally, in this context, you are able to build trust and confidence not only with potential clients, customers, data subjects, and citizens, but also with your business partners and the authorities. What is more, using our criteria, of course, you are able to extend compliance to other regulations, as is the case here, because it all started from a GDPR certification, and now we are moving on to extend compliance to other regulations, such as the Data Act and the extensions that Sebastian mentioned before, leading you to develop a competitive advantage. Of course, compliance is often viewed as a liability, I would say, and something that brings additional cost for your company. But in practice, it can be turned into additional revenue if you're able to use it smartly, I would say. Of course, the idea behind the certification is to be able to support data transfers. And this is a key point for the Data Act criteria as well, while also receiving continuous regulatory updates. As I mentioned, the criteria and the documentation that you can find in the community website is constantly maintained and updated in order for you to not miss any news or changes in the legislation and regulation. And overall, this entire process is meant to assist you to simplify the regulatory compliance. Because of course, we all know that if you have to comply with multiple regulations that are covering similar or even the same topic from a different perspective, it can be rather difficult to keep up with everything and keep your documentation and all of your compliance activities up to date. Certification comes here to show you a simplified way of achieving this part of regulatory compliance. Overall, our approach with certification is that you are able to turn compliance into value. And this is exactly what we are trying to do. So what you can do if you want to pursue this further, if you want to get more information, of course, you can contact us at contact@europrivacy.org, or you can visit our websites, our Europrivacy Online Academy, our Europrivacy Community website, where you can find all of the documentation, and also the criteria to document your compliance and then pursue further certification. And you can also follow us on LinkedIn, where we usually post updates about our upcoming extensions, schemes, and upcoming activities such as webinars. And very soon, our dedicated webpage for the Data Act certification will be active under dactcert.com. So you can also keep track of that website for further updates. And I think I can also give you the floor back, Sebastian, if you want to say some words about
with great pleasure. And maybe just a last element which can be of interest. The European Center for Certification on Privacy is actively engaged in building this bridge between the research community and the market and the society, the industry. But we're also actively engaged in supporting different activities, including the Privacy Symposium Conference. So the next edition of the Privacy Symposium is planned in Venice from May 12 to 16. And it is a conference where we bring together the different authorities, different regulators, not only from Europe, but from other regions of the world, experts, industries, to discuss, reflect on the evolution of data regulation. There will be dedicated session on the Data Act. I think that Malte, you are already confirmed as your participation, so you will have the pleasure to meet Malte in person if you attend the conference, but also different DGs, units, the EDPB, EDPS, but also authorities from other parts of the world, from US, Canada, Brazil, Japan, Singapore, and others. And there will be also a dedicated series of sessions on data certification, on data regulatory compliance certification, and international cooperation among authorities worldwide. So that could be of interest. And there will be also quite a number of research results that will be presented at the conference too.